Thank you all for being here today. We really appreciate your interest. We're here today to announce a historic resolution for Washington State, one of the largest in state history. After rejecting a national settlement last year, which virtually every Attorney General agreed to, today I'm announcing an agreement in principle that will result in 3 of the largest opioid distributors paying Washington State more than $500 million for their role in fueling the opioid epidemic here in Washington State. These resources will help Washington State address this crisis, this epidemic that touches every community in our state, and as you will hear shortly, many, many families. These Fortune 15 companies are McKesson Corporation, Cardinal Health, and AmerisourceBergen Drug Corporation. My legal team, including many of the individuals behind me, has been in trial against these 3 companies in King County Superior Court since November. It's been a lengthy trial. We could have joined the overwhelming majority of states and settled these distributors a number of months ago, but we chose to fight them in court instead. Our decision, that decision to take these distributors to court, will result in significant additional resources for Washington to combat the opioid epidemic. These resources will increase prevention efforts and help Washingtonians in need, including providing necessary wraparound services for those experiencing homelessness as a result of their substance use disorder. We forced these companies to stand trial for their conduct, right here in downtown Seattle in a courtroom for the last many months. And as a result, Washingtonians will receive $46 million in resources we would not have received had we accepted the national settlement before going to trial. This case is, of course, part of a larger effort in my office related to the opioid epidemic. And that initiative has 2 simple goals. First, hold those responsible for the opioid epidemic accountable. Second, recover as many resources as possible to address the ongoing crisis and begin to heal our communities and our families. I'm joined today by a number of folks, including, as I mentioned before, my legal team. I'll introduce just 2 of those folks for the sake of time, and that includes our complex litigation division chief, Jeff Rupert, and also Assistant Attorney General Laura Clinton, who led our trial team. You may hear from either of those individuals when we have our questions later on, if there's detailed questions about this agreement in principle. There's a much larger trial team, as you might imagine, for a case of this complexity and duration and significance. And they've been hard at work, putting it mildly, for a long, long time. Look, I used to work for a large law firm. I have a sense of the resources that large corporations have when someone takes them on. And those resources are virtually limitless. That's just a fact, right? And so, we can, as the people's lawyers, our job is to match that as best we can and hold them accountable. And that's what this team and many others who have been part of the office have done for a long, long time. And so this outcome is due in no small part to their willingness to take on a very, very complex undertaking and to do it extremely well. I'm also joined by 2 individuals who will be speaking after I speak. These are individuals personally impacted by the opioid epidemic. To my right is Rose Dennis. Rose has spoken before alongside me at a press conference, seems like a long time ago now, Rose. Mm-hmm. And she will be discussing her family's, the impact on her family of the opioid epidemic. And to my left is Skagit County Commissioner Lisa Janicki, who has a role, of course, as a policymaker in Skagit County, but also be sharing her own personal story as well of the impacts of the epidemic on her and her family as well. So I want to thank you both for being here. It's not easy to tell one's personal stories, especially the stories you're about to hear from them, so we deeply appreciate you being willing to be here. So first what I'll do is give a brief overview of a very complex case against these three distributors. Second, I'll go into some details about today's historic resolution, including what this will mean for our communities here in Washington State. Third, I'm going to try and contextualize this specific announcement within the framework of our broader effort in this office to combat the opioid epidemic and explain our next steps in that fight. So we filed this lawsuit in 2019 against McKesson, Cardinal Health, and AmerisourceBergen. These three companies, again, Fortune 15 corporations, supply the majority of opioids that come into Washington state. To give you a sense of scale, between 2006 and 2014, they supplied more than 2 billion opioid pills to Washington. Opioid distributors are legally required to monitor opioid orders they receive, looking for specific factors that can identify suspicious shipments that could be diverted to the illegal drug market. So, for example, if a pharmacy suddenly triples its order quantity, that's a red flag. Or if a pharmacy that typically orders once a month suddenly places an order once a week, that's a red flag. If they determine that the order is suspicious, distributors are legally required to stop the shipment and report the suspicious order to the Drug Enforcement Agency. These three companies did not fulfill that obligation. Let me just give you a couple examples. In 2014, these three companies shipped enough opioids to Pend Oreille County, just to use one example, to supply every single man, woman, and child in that county with dozens of pills. These distributors had a legal obligation to stop suspicious orders and report them. Because they did not, more opioids flowed into Washington state. That led to more opioid prescriptions being filled, more of these dangerous pills finding their way into the illegal drug trade, and, of course, more addiction and devastation. The sheer volume of pills flooding the market is a key contributor to that devastation. In 2015, there were 8 counties in Washington state with more prescriptions, not pills, more prescriptions than people. Clallam, Grays Harbor, Columbia, Garfield, Asotin, Pend Oreille, Lewis, and Benton. More prescriptions than people in those counties in 2015. These three companies knew or should have known they were shipping suspicious orders into our state. They had a legal obligation to stop the shipments and report them. They did not, and today they will pay more than $500 million to Washington state as a result of their actions. Let me briefly outline the resolution of this agreement in principle. So as a result of our case, if approved by Judge Scott, that's our trial court judge, and I'll talk a bit more about that in a moment, these three opioid distributors will pay $518 million to Washington state. McKesson pays about 38%, Cardinal Health about 31%, AmerisourceBergen also about 31%. That's the breakdown amongst those three. The overwhelming majority of this amount, $476 million, must be used to address the opioid epidemic. This has been something I've been clear about since first filing this case, that anything we recover from this case, from a verdict or a settlement, must be used to address the opioid epidemic and not simply backfill the state's general fund with other needs. The bottom line is these resources must be used to heal our communities that remain in crisis. By the way, one thing I should mention is when we complete our process, which I'll talk about of finalizing this deal, the end result will be an order signed by Judge Scott. That's our trial court judge. That order will be specific that these resources must be used to abate the opioid epidemic. In other words, a court order will say that's how the funds must be used. So these significant funds will be used to help our communities. I want to give you some examples of what that means. Ultimately, the strategic spending decisions will be made by the legislature and, of course, our local city and county councils, folks like Lisa at Skagit County. But all the money, I want to underscore that $476 million must be used consistent with the consent decree that Judge Scott, we anticipate, will ultimately sign. The consent decree aligns with our state's opioid response plan. It has approved strategies for addressing the opioid epidemic. So these are examples of how these funds can be used in our state by policymakers like the legislature or by Lisa at counties and cities. Improving and expanding treatment for individuals suffering from opioid use disorder. Supporting individuals in treatment and recovery, something we hear over and over. We simply do not have anywhere near sufficient resources to address that need. This includes providing comprehensive wraparound services to individuals with opioid use disorder, including housing, transportation, education, job placement, job training, and childcare. Addressing the needs of pregnant women and their families, including those with babies with neonatal disorder. preventing opioid misuse, overprescribing, and overdoses through, among other strategies, school-based and youth-focused programs and public education campaigns. Local governments can allocate additional resources for legal expenses if they choose. The following will constitute the remainder of the $518 million recovery. So $476 must be used with those strategies I talked about. That'll be under a court order. The remaining amount will be broken down as follows. Approximately $10 million covers direct trial expenses. For example, hiring an expert to provide expert testimony at the trial. Big, complex trial, about $10 million covers direct trial expenses. Approximately $11 million will go toward the legal cost of all Washington local governments. So there's about 37 or so that filed their own lawsuits. They've got their own legal expenses. That's where $11 million will go. And approximately $20 million will go towards the fee for our outside counsel that assisted my legal team over the past 3 years, Motley Rice. They'll receive $20 million. In total, of the entire amount that the state is receiving, about 6% goes for attorney's fees, which is a fraction that you would typically see for a case of this magnitude. This resolution is not final until all litigating Washington jurisdictions, those 37 or so jurisdictions that filed their own lawsuits, and 90% of non-litigating jurisdictions with a population over 10,000, that's about another 85, agreed to the proposal. This is what all the other 48 states had to do as well when they signed on to the national deal that I refused and they went to trial. They had to get their local jurisdictions, enough of them to sign on to it to complete the deal. All of them did. So I do not anticipate any problems with getting those jurisdictions to sign on to this agreement, frankly, because Washington State is doing better under this deal than those 48 states did. Our deadline for completing that is September 23rd, and that's when Judge Scott would need to agree to the settlement at that time. These payments were made over a period of 17 years. That's also the same period you saw in the national settlement as well, and that virtually every state agreed to. Today's resolution is, of course, an extremely important victory, but it is most certainly not the end of our initiative to combat the opioid epidemic in the state. This is not our first major case against a powerful company whose conduct contributed to the opioid epidemic, and it will not be the last. This victory marks the second time we secured significant additional resources for Washingtonians by rejecting a national settlement that virtually every Attorney General accepted and choosing to fight in court instead. Our state has been one of the most aggressive in the country in taking the fight to these powerful corporate interests in order to secure the most possible resources we can for our communities. You may recall that Washington State led a coalition of states that contested and fought the original bankruptcy deal with Purdue Pharmaceutical and the Sackler family. Noah Purcell, my Solicitor General, flew back east to argue that case. We won. As a result of that, we got significant additional resources for Washington State. When you combine the outcome of today's case with that Purdue Pharmaceutical case and the Sacklers, we have now recovered a total of more than $700 million for Washington State. $159 million of that is additional resources to combat the epidemic we've won as a direct result of rejecting national deals and litigating instead. We could have chosen to accept those national deals. The decision to reject those national deals was frankly a difficult one for me. As you might imagine, we're talking about an awful lot of money, and there are risks with litigation. Any lawyer will tell you that. And the risks are profound when you're talking about hundreds of millions of dollars. But we believe we made the right decision to challenge these jurisdictions, and these results speak for themselves that they turned out to be the right decision. But our work is far from over. We're actually now, after the team takes a little bit of a breather, they'll be getting back to work on a trial we have scheduled for later this year in September against another opioid manufacturer, Johnson & Johnson. That trial is scheduled to begin here in Washington State on September 19th. So these cases are, of course, about accountability for these corporations. Just maybe one thing I'll add before I turn this over to Lisa next is, and I think this actually happened with you, Lisa, but pre-COVID, especially when I was traveling the state and speaking to Rotary clubs, or I'd speak at a law school class or wherever it would be, and I would speak a lot about these cases and about the opioid epidemic. It just became part of what I would talk about before any kind of group of Washingtonians. I was talking about the work of our office. It was just that important and in the news. And I remember whenever I would do that, virtually without exception, after I would finish my talk and people come up to say hello to you, somebody would come up and say, "Hey, Bob, can I talk to you for a second?" and they'd kind of pull me aside. And I knew exactly what they would say. Right? We had a conversation like this, right? I knew exactly what they would say at that point. They would say, Bob, I had a child who suffered from addiction, or a coworker, or an uncle, or a friend, whatever the case was. And it just really brought home for me. I mean, obviously, intellectually, I understood. You look at the numbers, like, my God, right? There's a crisis. They don't call it a crisis for nothing. But there's something about meeting that many Washingtonians and just realizing, hey, I'm just talking to 30 people in this room in Sunnyside, Washington, and someone's going to come up and talk about their personal experience with this epidemic and what it meant for them. And one thing I heard a lot from those individuals was that the money's important, right? The money's important, but what they often said was, take them to court. Take them to court. I want to hear what they say in a courtroom. I want their employees to have to testify under oath. I want that evidence to come out. And so, while that's a challenging decision to take that route, and there is considerable risk, there's just no getting around it. But we feel, I think, as a team, as an office, I think Lisa and Rose agree, and many others, that that's a fight worth fighting, and that I'm just so proud of the team. I'm so thankful for Rose and Lisa for being here to share their stories, which are really the most important part of this press conference. And so with that, I'm going to turn next to Lisa, again from the Skagit County Commissioner, who will be sharing her personal story as well.
Thank you. Well, good morning, everyone. My name is Lisa Janicki, and my role of County Commissioner is really secondary to my role as mother, family member, and in the story that I have shared the story before. But our youngest son, my husband and I have 5 children. Our youngest son, Patrick, died of an opiate overdose almost 5 years ago, and I used to walk into his room and see prescription bottles following an accident that he had in a climbing demonstration, ironically at a county fair, while he was in college. And when he, as he was in college, the number of prescriptions that he was taking would come home during summer breaks, and I would just say, Patrick, what are you doing? You've got to do something to cure your back pain. It isn't just about pain pills. But every time I'd pick up these bottles or these boxes of patches, it was always our doctor's name was on those patches or on those prescriptions. And it was in 2016, Patrick came to me and said, "Mom, will you drive me down to Longview? I'm addicted to pain pills, and I'd like to check myself into treatment. They have a room available for me." And it was just such a shock. I looked at he didn't fit the demographic. Intellectually, I'd seen all the numbers and the people who were on the street and the visible epidemic, I'll call it, of substance use, and thought, he's college educated, he's an Eagle Scout, he's employed, he has health insurance, he has a loving and supported family, he has a place to live, and just never anticipated this message of, I'm addicted to pain pills. And you fast forward that, and he went through treatment, and he got out, and the family was so supportive of him, and he was on a medically assisted treatment, Suboxone. So I became educated about what Suboxone is and what are opioid receptors and how long does it really take to be, can your body ever really wean off of that impact of opioids? And Patrick was in recovery for about 6 months, and he says, "Mom, I don't want anything in my body. I want to go back to treatment and get Suboxone. I want to be off of everything. I want to be clean." And I thought, that's a great idea, Now, my public health, Board of Health hat said, wait, there's, it takes up to 2 years or longer, or maybe it's like diabetes and you always have to have medication for this disorder. But I thought, my son can beat the odds. My son can be better than those numbers. He's got the people structure, he's got the infrastructure, he's got the personal desire. He checked himself in. And so he went through treatment, and it was rough coming off of Suboxone. But I have to tell you, within just a month of him being back out of treatment, and I thought in recovery, he was using again. And that summer, he ingested a pill that had fentanyl, and we were the fortunate family. We got 2 weeks to say goodbye to him, and he died here in Seattle, at a hospital here in Seattle. And the visitors, that came to say goodbye when a 30-year-old man dies is just overwhelming to the whole system. So I use that as the background for my role as county commissioner. I'm also Board of Health for the county, and the opportunity that this settlement would bring to local jurisdictions and to the state to be able to address firsthand our shared story, unfortunately our shared story, would be just phenomenal. We have to be able, as society, to put programs in place that have a known funding source and strategic goals around the wraparound services that can be provided, how to meet people, the users, where they are now, but to have some place for them to go when they say, I'm ready, I want to go to treatment, I need support with recovery, I need a place to live that is clean. And to me, that is the most exciting part, is that the dreams that my public health and my population health trust, my advisory board of health will say, is that if there's a known funding stream, we can make the long-term commitment that we need to actually battle this disease. So I just really want to thank you, Bob, and your team. I feel like I'm like the A-team is all around me, but really from the bottom of my heart, it's gratitude that I feel. And I once said, this happened to my son, this happened to my 30-year-old Patrick. It shouldn't happen to anybody else. And I really believe that with this systematic and combined effort to move forward, to be vocal about what substance use is and what it isn't, and to recognize the needs that are out there, we can really keep any other family from having to stand up here and tell their story of their own child's death. So, Bob, thank you so much.
Lisa, thank you so much for sharing that story again. And next you're going to hear from Rose, who I've had the great pleasure to get to know, I guess now over a number of years. Mm-hmm. And she stays in touch with what we're doing here in the office, and we've met now a number of times, and her willingness to share her story is one we deeply appreciate. So thanks for being here, Rose.
Thank you very much. Good morning. Again, my name is Rose Dennis, and I've been invited here today to share my story that opioids kill. My son, Matthew Dennis, died on January 3rd, 2021, at the age of 36 from opiate addiction. He fought the disease of addiction since the age of 13 because he was placed on an opiate drip while in the hospital locally fighting for his life with AML cancer. After 1 year of treatment, he left the hospital free of cancer, but with the disease of addiction. My husband and I were told by the medical team that only 1% of patients that were given opiates would become addicted. We were both deeply concerned about the impact that opiates would have on Matthew. And it turns out that only 1% become addicted is false. It's not true. And it was then and is still today. It's not true. Also, the hospital then did not have doctors or therapists needed to address the disease of addiction. We were on our own to solve this problem. Young children should never have been given opiate medications to begin with, and they should not today be given opiates. The disease of Matthew's addiction impacted our family for 23 years. It was heartbreaking to see him suffer, struggle, and steal from us. He was in treatment over 15 times, but the addiction controlled his brain and he could not stop using. And when he was clean, the longest was 1.5 years, and those triggers reappeared in his life, and he wanted to use again. We had to have him leave our home because the decisions he was making were not good, and we did everything we could to help him, but we could not. It was not our problem to fix. It was not our problem to solve. He was deeply loved and is greatly missed. My heart is broken and my family is deeply saddened that Matthew had to die because of the greed of so many who decided not to follow the rules. This should not have happened to him. I was able to spend almost 3 weeks with him when he was put in hospice care in Everett. And it was just, I'm glad, like you, Lisa, that I had that time with him to say goodbye, but it just wasn't something any mother should have to do to their with their young child. There is so much more that needs to be done to help those who live with the disease of addiction. And I say the disease of addiction because it does kidnap the brain to where they cannot control it. Those impacted do not deserve to be forced to live on the streets of every city with no housing, no medical care, and no resources. With the successful wins in court in our state, it is reassuring that our state policymakers can now implement new policies so that opiate addiction can be medically treated in a timely manner, and the new resources will provide what is needed so they can now live a healthy life, which is what they deserve. We cannot continue to turn our backs on this disease. A sincere and big thank you to Attorney Bob Ferguson, Attorney General, excuse me, and to your team, all of you, thank you, who have worked diligently proving in court and winning the monies requested because you were able to present how the pharmaceutical companies and the distributors selling opiates in our state were breaking all of the rules. So thank you. These successful rulings now require them to be accountable. Imagine that, be accountable for creating the opiate crisis. Thank you again for this opportunity to share my son's story.
Thank you, Rose. And so I think we have, for the folks on the line, I know we have, I think, a number of folks on the line. We have a few folks here in the room, so let me start here. Folks have questions here, and then for those who are waiting on the phone, we'll then turn to the folks online. I will do my best when folks ask questions on the phone, if they have any, to repeat those for the folks who are here, because sometimes it's hard to hear, and we'll do our best to answer them. So does anyone have any questions here in the room?
You mentioned the distributors and the manufacturers. What about the doctors? What's their role in this? What, did they violate any laws of these prescriptions? I mean, they're the, I guess by the stories we're hearing, the last stop before it gets to the patient.
Mm-hmm.
Yeah, so the question is for those who are listening who may not have heard it, it goes to what about, for example, the doctors, other players who have participated in this? I guess a couple things I would say is, so number one, no one case covers everything, right? This became an epidemic because, to your point, multiple individuals, multiple companies, multiple corporations violated the law. So this happens to be a larger case, right? This is one of a huge magnitude. But yes, there have been plenty of pharmacies, individuals, companies, corporations that have violated the law. So this is part of an overall initiative. The state also has its own work that it does to hold doctors accountable, right? And we have ongoing investigations going on with other actors as well. So this will not be the last case you see from us. As I think you know, we don't make our investigations public until we file something. That's just our policy, which is different than many state AGs. But this is an active body of work that we have with multiple actors in this industry. But this just happens to be an especially large entity who had caused a disproportionate amount of harm.
Specifically, what laws were broken? You mentioned the idea of notifying if there's a change in orders and all that, which a lot of it sounds like self-policing within the industry, which I guess doesn't seem to work, but what were the specific laws that were broken?
Yeah, so in Washington State, for example, we have a Consumer Protection Act, right? You cannot engage in unfair or deceptive business practice. So for Washington State, each state's a little bit different in what allegations they can bring, but for Washington State, a key claim of action that we brought was a Consumer Protection Act violation. Another was a nuisance. They're causing a public nuisance. It's kind of a legal term, but a public nuisance here in Washington State. So those were key claims that we had throughout this lengthy trial and this lengthy case against these distributors. So those are key tools we have in Washington State. Again, each state's positioned a little bit differently in which laws they have, and even their Consumer Protection Act laws can be a little bit different, but those are key ones for us. Any other questions here in this room? If not, let's try going to folks online. I think we're unmuting, and I know it's a little challenge if folks speak over, but we'll do our best. And if you can just identify yourself and who you're with, and we'll do our best to get through them.
Hi, this is Gene with the Associated Press.
Go. So I hear a couple of voices. I heard Associated Press, so whichever that voice was for Associated Press, let's start there.
Hi, Attorney General Ferguson. This is Gene Johnson with the Associated Press.
Hi, Gene.
So last summer, when you rejected the national settlement, the announced value of that to Washington State at the time was $527.5 million. You expressed concern about the real value being closer to $300 million with inflation because it was being paid out over 18 years. Now today we have a $518 million settlement that's being paid out over 17 years. Can you sort of explain how this is somehow more than the settlement that was offered last summer? And then also explain how this is adequate when the state was seeking tens of billions of dollars at trial.
Yeah, Gene, I'm not sure what your first number was. Our press release details kind of the numbers, but this is for Washington State. What we're receiving here from this resolution will provide an extra $46 million from the national deal that I rejected. So I can have Brown to follow up with sorry, Gene. So my team's saying that number maybe that you're referring to included Johnson & Johnson as part of that resolution, which would have been, of course, they're not a part of this deal. We're going to trial against Johnson & Johnson.
Okay.
So for us, I appreciate my team pointing that out because I wasn't sure what number you're referring to, but whatever you're reading from must have been a release or a publication that referred to a national deal that included not just these three distributors, which are the subject of this resolution, but in addition, Johnson & Johnson. So this resolution, of course, just the three distributors. So the amount we would have received from those three distributors from that national deal, take out Johnson & Johnson, of course, and their contribution was much less than what we're receiving today. And so I can have Brown still follow up, but I think that's probably clear. And again, just to repeat, we go to trial against Johnson & Johnson in September. And so just in terms of your overall question of, hey, I think you're saying, is this enough? I think you're asking, and I guess what I would say to that is, Gene, look, no dollar amount is enough. Let's start with that. No dollar amount's enough for Rose and her loss. No dollar amount is enough for Lisa and her loss. No dollar amount is enough for anyone who suffered a loss like that in our state, of which there are many, many individuals. So I'll start with that, number one. Number two, it is by any measure a significant amount of money. I mean, $500 million has to be one of the 2 or 3 largest resolutions in Washington State history from a case brought by the AG's office. Tobacco would have been bigger. I'm not sure if there's another one bigger than that. So it's a significant amount of money. Number 3 is the fact that we as a state, now in our second big case, are doing significantly better than other states who take that national deal. And look, does a part of me want to take this thing all the way to a verdict from Judge Scott? You bet. You bet. But as my team here knows, virtually every day of the trial, we have a check-in about how that day went at trial, and my job is to evaluate the risk. And it's a pretty bad day at the office, and more importantly, a pretty bad day for the people of the state of Washington if I take that risk, go to trial, and we lose, or we don't get this much money in a judgment in our favor. And so I just have to balance that out, and I'm not suggesting that's easy. It's a challenge, but I believed that this resolution, which brings in nearly $50 million more for Washington State than we would have received had I signed the original deal, is obviously a very positive outcome for the people of the state.
Okay, thank you.
Thank you.
Hi, this is Lindsay Arrington. I just wanted to share a few words, if I may.
Sure, Lindsay, can you tell us which organization you're with?
Absolutely. So Attorney General Ferguson, you and I have exchanged emails. I am one of the victims in the Purdue bankruptcy case, and I also run a nonprofit called Hope Soldiers, which helps people find freedom from addiction.
Thanks, Lindsay.
Thank you. I just wanted to express my gratitude to you, your staff, and your team. I can't imagine the countless hours that you have all spent trying to fight for people just like myself and people just like Rose's son and Lisa's son. And I just wanted to share how much it means to me as somebody who continues to fight on the front lines to help people find freedom from addiction and help people navigate a path to recovery. This means so much, and the fact that you are willing to go for it and hold these companies accountable when they undoubtedly are a huge reason why we have a crisis to begin with and a pandemic to begin with. I just sincerely wanted to thank you, and I really look forward to possibly working with your office in the future to continue to help people who struggle with addiction and the families that are affected by it as well.
Lindsay, hey, thank you so much for sharing that, and really more important, that thanks for all your work. It takes a community to address this epidemic, and we really appreciate. Rose is nodding next to me. You can't see her, but she's nodding next to me. So we just really appreciate all you do as well. So thanks for sharing that. We appreciate it. Are there any other questions from? Go right ahead.
This is Dietrich Knapp from Reuters.
Go right ahead.
So this sort of builds on the question you got from the AP. I think you were asking for $38 billion in abatement. So I just want to see, like, what are the plans for abatement and ensuring that this money goes towards addressing the crisis? Like, who's going to be in charge of spending it? What are the guardrails in place? Is there legislation that puts this in a special fund, or what are some of the ways that you'll supervise and report on the funding to make sure it does go to the correct uses?
You bet. Thanks for that question. I'll try to repeat and sort of more clearly maybe from my remarks about what we're doing to make sure the money goes for those purposes, and what I think the question you had, the word you used might have been guardrails. And so first, there's a process now to get local jurisdictions to sign on to this deal, just like all the other states had to do. We don't anticipate having a significant challenge with that. All the other states got their local jurisdictions to sign on. At that point, Judge Scott, our judge in this case, needs to, of course, sign on to the settlement agreement. As a part of that legal document that Judge Scott will, of course, hopefully ultimately sign, that legal document, that court order, will specify that those funds must be used for abatement related to the opioid epidemic. So the first thing I would emphasize is there will be a court order in place. There's not just a settlement and a bunch of money coming to the state of Washington where the legislature can do whatever they want with it. Quite the opposite. There's a court order that is specific about the use of those funds. So that's number one. Number two, and I think I gave some examples in my remarks, and I think they're also in our release as well. I'm quite sure there's a large number, but there are specific strategies that can be used consistent with that court order, right? That use of abatement, that local elected officials like Lisa here, or the state legislature, for example, they must work within those strategies. Treatment, for example, assisting pregnant women if they have neonatal issues, housing, for example, for folks with opioid use disorder. There are very specific strategies that are accepted ways to use these funds to abate the opioid epidemic here in Washington State, and they must stay within those specific strategies, and of course must stay consistent with a court order that we anticipate Judge Scott ultimately signing in September. And so this is different. So this is different than, just as another way of saying it, than the tobacco resolution, which did not have those guardrails, right? And maybe one more thing I'll just add is, this has rightfully been a question I've gotten throughout this litigation is, hey, Bob, what can we do to ensure that this is how the funds will be used for abatement? And I've been equally clear with any Washingtonian I've spoken to that I will do everything in my power to create those guardrails to make sure the money goes for those purposes. And we believe when this agreement is ultimately signed by Judge Scott, that will accomplish that.
Just to quickly follow up, so are those decisions about those strategies and which get funded, is that going to be made like at the county level? For example, like one county says we have a greater need for, neonatal abstinence syndrome, that we can put more money towards that, or is there going to be some kind of formula, or is it going to, I just want to know, like, who's, do you understand the question? It's like,
yes.
There's obviously not enough money to fund everything.
Correct.
So decisions are going to have to be made, and just where, what level of government those are going to happen at.
That is correct. So, and Lisa, I'll ask if she wants to jump in here in just a moment, but what you'll see is, without getting sort of too much in the weeds, but sort of two levels of government, that the dollars will be ultimately split, speaking broadly, between the state and the local jurisdictions. So that's number one. So for the state, for example, that's the state legislature, right? Works on, hey, which strategy do we think, to your point, we think the state needs to focus these resources on? So that's our state legislature, the policymakers for the state making that decision, working obviously with, hey, folks who work in state government who are experts in this type of thing. Part two, the local jurisdictions will make their own jurisdictions with their a portion of these resources. And maybe now what I'll do is just see if Lisa wants to maybe give an example from her perspective as a county commissioner as well of what that might look like for one particular county, Skagit County here in Washington State. Lisa.
Yes, thank you. So this is Lisa Janicki. And so, for example, in Skagit, as I'm thinking through this, the county, so county and county public health works collaboratively with our mayors. We have a formalized group, and we're actually going through a prioritization, strategic planning with all of the cities in our county to address behavioral health. So that umbrella of both the mental health needs and the substance use disorder itself. And so collaboratively, we utilize that group to look at how to best deploy ARPA funds. Was one of the uses. How to address homelessness. We set up a homeless shelter a year ago with that collaborative group, and the expansion of services within the county to the folks with substance use would be a logical programming need to bring in front of this particular group. In addition, for Skagit County, we also have a 5-county regional group, so that kind of the northwest corner of Washington State, that we work together on 3 priority areas, and behavioral health, again, the mental health part that goes with substance use, is a priority area there. So I guess the most important thing from my perspective is to be able to demonstrate back to the public that these hard-earned settlement funds are used wisely, effectively, and have outcomes that can be measured. So that's how I see it happening in Skagit County.
Okay, thank you.
Thanks for that question. And if you have a follow-up, feel free to reach out to Brown if you got a follow-up, but hopefully that took care of it for you. Thanks so much.
Attorney General Ferguson, it's Austin Jenkins with Public Radio. And I have a couple of questions, but can you just help us with the numbers again? And I wanted to refer back to that press release that Gene mentioned from last July as the starting point. The multi-state settlement for the 3 opioid distributors at that point was going to be $418 million over 18 years. And then you threw a lot of numbers at us. You mentioned 518 and 476.
Yes.
Can you just walk us through?
Sure.
Starting with the 418, which was the offer on the table almost a year ago.
Correct.
What is the state getting now?
So the state's getting the $518 million is the settlement for the 3 distributors, not Johnson & Johnson. Right, to that question earlier, not Johnson & Johnson.
Yep. We're not talking Johnson & Johnson.
So I realized, and so I appreciate you guys pointing that, because that is obviously significant. Number 2, the $476 million figure, that is the amount of the $1,518 that will go directly to abating the opioid epidemic in Washington State. And I'll go back to my notes. I think also I just walked through where the remaining dollars, the difference between those two
Yeah,
figures.
I got that part.
Okay, good.
Thank you,
Okay.
Attorney. So essentially, it sounds like you improved upon the multi-state settlement by $100 million, and about 60% of that will go to, well, about half of it will go to lawyer fees and expert witnesses and such, and about half of it will go to will add to the abatement.
Yeah, I think
Is that right?
I think the simplest way to articulate, and I understand there's a lot of numbers and
Yeah.
a different deal, so we've spent some time to try to make it sort of as transparent as possible. What's extra for Washington State for the abatement? Okay, well, what we're going to have beyond the national deal that we're bringing as a result of this settlement, what's extra that we would not have gotten had we signed the national deal. I think the simplest way to articulate it, we can break it down for you more via email if you want, but it's $46 million is extra money that's going to go to abatement, right? Not to the cost or the fees or anything else, to abatement that we would not have received had we accepted the national deal several months ago. So that's the extra amount that we're getting as a result of this deal that goes to abatement, and only abatement, by the way. Like that, it's part of this deal. It's got the same limitations. It'll be under the court order. It'll be subject to those strategies I talked about earlier, and I think answering, maybe it was Gene's question, and answering one of the earlier questions.
And do you know just what that will mean then for Washington State and its 320 cities and counties on average per year over the 18 years?
Oh.
And that was about 23 million into the multi-state. Do you know what that'll bump up to now?
You know, Austin, I bet we have that. I'm sorry, I just don't have that specifically at the tip of my fingers. I don't have that. We tried to limit the number of numbers we gave you. Maybe we should have given you more, but I don't have that at the tip of my fingers right now.
I guess the fundamental question I have then,
Mhm.
I'm struggling a little if you decided not to accept the multi-state offer and go to trial, and then you're agreeing to, why didn't you wait for a verdict in this trial? It sounds to me like maybe the tea leaves were suggesting that this wasn't going to turn out well for the state, and it made better sense to settle in essence. And I'm just a little bit perplexed because I understand that you're saying 42 million seems like a lot, but it's not a third, a half, or doubling what was being offered at the multi-state level. So what happened between the decision to go to trial and the decision to settle before the trial is over, rather than see what the jury decided?
Sure. So just to be clear, so 46 million, I think you said 42, but 46 million is the extra amount we're receiving, number one. Number two, I guess what you're asking is an important question, and I guess what I would say is 47 AGs answer that question like in the following: I don't want to risk going to trial, so I'm taking the deal. Okay? That's how they answered that question, taking the deal. I came to a different decision. That was, I can assure you, Austin, a difficult decision that I spent an awful lot of time thinking about and talking to my team and speaking to people like Rose, right, and Lisa. Look, if you told me when I was in law school that someday somebody would offer me $400 million for my client, I would say no. I would have said there's no world in which I would ever say no to a $400 million resolution of any kind of case, right? That's just such a big number. But I said no, knowing the risks are always significant when you go to trial, okay? And these corporations have all the resources, money combined to defend themselves. So once we made the decision, went to trial, but as you might imagine, and I think I emphasized, we were in a continued state of examining that risk. Because the one thing I could not have happen is we lose, or we get a positive judgment from the judge, but it's less than the national deal. I just don't know what I would say to the people of the state of Washington if that had been the outcome. And so throughout the course of the trial, we had some decisions from Judge Scott that went our way. We had some decisions from Judge Scott that he knows we disagreed with. We articulated that in court. And as we assess things going forward and reach the end of the trial, obviously, settlement discussions began in earnest at that point. And for me, in balancing those risks with, I might add, even if we win, they're not going to write a check the next day, right? That's not what's going to happen. You've got years of litigation through the appellate courts. And you saw just with the grocery manufacturers case we had on a totally different context, it was literally years they tied us up in court before we finally got the money in that case. So getting the resources now was important. Getting more resources, significantly so, 46 million more than we would have had we signed just a few months ago, was also significant. And then eliminating the risk, sort of third prong, it was those three factors that led me to this decision.
Okay, and just briefly by way of follow-up,
Mhm.
First off, no admission on their part of violations of the Consumer Protection Act or public nuisance in this consent decree, is that right?
That is correct.
Okay, and why? Because, and I want to go back to Gene's point about your press release last year, which was when you factor in inflation and the time of how long it will take for these payouts to happen, you made a very strong point that this wasn't a great deal for the state of Washington. So even if you were going to agree at the dollar amount you've settled on here, why were you not able to drive a harder bargain to get the money to the state and the cities and counties faster? Because clearly a concern of yours almost a year ago was that 18 years factoring in inflation ended up not being a good deal. It was taking too long and you were losing value on those dollars over that time.
Correct. And so, look, does that remain a concern? You bet. But the fact that we're adding $46 million to those payments, to me is, well, it speaks for itself. It's 46 million more than other states are getting, right? It's more than those other states are receiving. And so what I just have to do, Austin, is balance all these factors out that you're speaking to, right? And look, I feel like I'm pretty tolerant of a high level of risk in the decisions I make as Attorney General in taking cases to trial, as I think you know from watching the work of our office on some pretty big cases. But look, I've got to balance that with getting the dollars in now. And when we realized we were getting nearly $50 million more than other states, and then eliminating that risk, while this by no means is a perfect resolution. I think no state AG would say it is for their states either. But it's hard to escape the fact that we are doing significantly better than other states, virtually every other state, who actually signed the national deal.
Okay, thank you.
You bet. So not hearing any other questions from those online, feel free to follow up with Brianna. And if folks have on the numbers, I recognize multiple entities. I realize there are a lot of numbers, but I think we try to do our best in our release to kind of lay that out. But feel free to follow up with Brianna if you have questions about that. One last question? Yeah, go ahead.
Off topic.
Yeah.
You're an attorney, you know you're going to have to answer this. Any reaction to the draft opinion from the Supreme Court that was leaked?
Sure.
Where it looks like they're planning to overturn Roe v. Wade.
Sure. So the question goes to Roe v. Wade. I'll be very, very brief. There's going to be a press conference this afternoon that I'll be having with the governor and a number of others. I think it's at 2:30 this afternoon. I think, and so I'll be there and can speak in more detail. Look, I'll just say that, what will I say? If accurate, okay, if accurate, and if that ends up being the opinion of the court or something close to that, it's outrageous. It's outrageous. The one thing I'll add is for Washingtonians, we are protected because there is an initiative in Washington State that ensures women their reproductive rights and freedoms here in Washington State, even if that opinion that we're seeing now was signed by a majority and released tomorrow. Women in Washington would not be impacted by that opinion. That said, that is cold comfort for millions of women who live in states that don't have those protections, of which there are many. So we'll speak more about that at 2:30.
I mean, couldn't the Congress then basically
Two,
ban it?
2:30. I mean, if you don't mind, 2:30, just because we've got folks here, we're folks here, but happy to chat afterwards as well.
Okay.
Yep, you bet. Lisa, do you have any final thoughts?
I'd like to just make one final comment, and I know there's a lot of discussion about the time value of money. I mean, my background is as a chief financial officer for 30 years, but controlling the time value of money can't compare to saving the lives that will be saved by deploying this money sooner than later. And I cringe at the thought of going through a prolonged litigation with all the appeals that follow that. And I know it's a tough road to hoe legally. I know that there's a percentage of whatever settlement comes out that will always have to go to paying some of the legal fees. And I have said publicly and more than once that I couldn't save my own child's life, but I sure as heck am determined to save somebody else's child. And I was challenged with that with someone who sent me an email that says, "You're right, you didn't save your own son's life. Why do you think you can save anybody else's?" With that being said, I know that if we get this programmatic money deployed sooner than later, somebody else's child will get into treatment and on a road to recovery a lot faster than if we let this languish in the courts. So time value of money isn't as important as the time value of children's lives.
Thanks, Lisa. If there was anything else you want to add.
Should I mention the Guardian Light?
If you want to add that, please,
Okay.
go forward.
Again, this is Rose Dennis, and again, the value of money it's now or never. And I know it's taken longer to get here than maybe we would have hoped, especially having a child who died from opiate disease. But opiates are just everywhere. And for example, I'm a guardian ad litem for Island County, and we represent children who are taken away from their parents because in most cases today over drug use. And some of the parents are able to get their lives back together so they can get their children back, and others cannot, and then the children have to be adopted. So the sooner we can address this, and now we have the money to do so, I'm happy about that. So thank you.
Thank you so much, Rose. And thanks everyone for being here. I guess just a final thought is just to reemphasize our work is most certainly not done. Trial against Johnson & Johnson this September. And we'll be continuing our strategy of rejecting national deals, taking these entities to court, and bringing back more dollars than other states are receiving because we're taking that aggressive approach. Really appreciate all the questions. Happy to follow up with folks on the phones as needed. Thanks to all of you here for being here as well. Thanks to my team. It's been a long road. We'll rest up a little bit and get ready for Johnson & Johnson, but they put an awful lot of time into this, as you all might imagine, and really appreciate their work. Thank you so much, everybody. Have a great day.